Yes. Hello guys, this is Advocate Amey Hadwale. I am a partner in a law firm called A&G Associates. We are based out of Bombay. We mainly practice into commercial litigation. My area of expertise, the core area is insolvency bankruptcy code. I have a fine amount of experience in practicing in NCLT matters. Uh, 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 I have been into insolvency bankruptcy code, practicing the code since the code was promulgated in 2016. So today's topic for discussion is drafting of liquidation petition. So before directly going into the topic, let me first give you a background as to the stages which are required or the circumstances which warrants the company to be put into the liquidation first. So, as we are aware, insolvency bankruptcy code are divided into two stages. Uh, one Stage one is the CIRP process, that is a corporate insolvency resolution process. And stage two, when the corporate insolvency resolution process comes to a failure, liquidation is initiated and the liquidation process commences. In the liquidation process, generally the role of the liquidator is to sell the assets first, try and sell the company as a going concern, or if that does not comes to a logical conclusion, try and sell the assets of the corporate debtor in piecemeal basis or on lump sum basis and dissolve the corporate debtor. Dissolve the corporate. When I refer to the corporate debtor, that means the company in question. So, as we are aware that why IBC was promulgated, in what circumstances the IBC came into effect, all of that we have discussed in the last lecture. We need not dwell into all of those aspects now. Let us now, before coming on the main topic, let us understand as to the role of the resolution professional into the CIRP. In a nutshell, let us understand how CIRP is conducted. And once the CIRP doesn't fructifies into a approval of a resolution plan, what are the circumstances in which the liquidation is initiated? So let us begin this. As I said earlier, I generally prefer using this site, CA 2013. It gives a very detailed understanding of the provisions of both of Companies Act and of Insolvency Bankruptcy Code. In Insolvency Bankruptcy Code, you can have the main provisions here. Then you will have regulations and then you will have rules. As we are all aware, before dwelling into the topic, just let me give you a background. As we are all aware that the main code, insolvency bankruptcy code, the main provisions, those are drafted by parliamentary, that is drafted by the legislature and is approved by the parliament. Under the insolvency bankruptcy code, there are the adjudicatory powers are given to NCLT, the National Company Law Tribunal, and the regulatory powers are given to IBBI, the Insolvency Bankruptcy Board of India. So the role of NCLT is to adjudicate upon the matters and to resolve dispute that is arising out of corporate insolvency resolution process or relating to the liquidation process. The role of IBBI here is to regulate and govern the entire working of the insolvency bankruptcy code and all the stakeholders which are attached to it. The role of IBBI also in governing, while governing all of this process, the role of IBBI is also to make regulations in relation to the code and fill the gaps or the lacunas or the shortcomings which are created while which are not addressed in the main provisions of the code. And therefore, the IBBI has powers to make regulations uh, and for to put them into effect, the regulations will have same force as that of the main provisions of the code. So similarly, once that is done, now let us come to the main corporate insolvency resolution process. So now, if you see in this the on this website, the entire the sections, the main sections of the insolvency code are divided into different chapters. First into parts and thereafter into chapters. So part two mainly deals with CIRP and the liquidation process of the corporate debtors. That is the corporate person. That is the companies. So chapter one are mainly the definitions and the pecuniary limits of triggering the code. Chapter two, sections 66 to 32 mainly deals with insolvency resolution process. Chapter 3, liquidation, mainly deals with section 33 to 54. So, as far as this lecture is concerned, our main topic for debate is how to draft a liquidation application. So, we will not enter into how liquidation process is conducted. We will confine ourselves to how liquidation applications are drafted, and only to give you a small, give you an insight, give you a fine understanding of how liquidation applications are drafted. We will have to have a small insight of how corporate insolvency resolution processes are conducted. So let us enter into it. So as you are aware, when a section 9, section 7 or a section 10 application is admitted by NCLT, the corporate insolvency resolution process in respect of the corporate debtor, when I refer corporate debtor, I mean company, is initiated and a resolution professional is appointed to manage the affairs. The primary responsibility of the resolution professionals are twofold. One is to keep the company as far as possible going concern, keep the business of the company as going concern, and the second objective is to conduct the corporate insolvency resolution process. So when I mean to keep the company as going concern, that means everyone knows that whatever the business the company is performing, try and sustain the company, to hand it over to a resolution applicant in whatever best manner the RP could do. And as far as second objective is concerned, when I say to conduct a corporate insolvency resolution process, there is a detailed process which is formulated from section 16 to section 32 of the code. So let us understand what are these processes. First, when an RP is appointed, he has to give a public announcement regarding and invite claims of the creditors. Once he gives public announcement and invite claims of the creditors will have to submit the claim to the RP, and the RP will then, after considering the claims, will either accept or reject the claim. After collation of the claims, will either accept or reject the claim. So after assessing all of those, he will constitute a committee of creditors. The committee of creditors are specifically comprised of only financial creditors. Financial creditors, I mean secure financial creditors or unsecured financial creditors. Both of them form part of committee of creditors. The operational creditors and the other creditors are not forming part of the committee of creditors. Why do the operational creditors do not form part of committee of creditors? There is a separate judgment called Swiss Rebels that mainly challenged constitutionality of the Insolvency Bankruptcy Code, that Justice Nariman has discussed in detail as to why operational creditors cannot form part of COC. Coming back to the topic, financial creditors form part of the COC. Once COC is constituted, the RP has to work under the directions and the guidance of the COC. After constitution of COC, the RP issues a Form G, conveys first COC meeting. First COC meeting, the COC will decide whether they want to replace the IRP or they want to continue with the same RP, same IRP. The same IRP is then confirmed as the RP or else replaced in whatever the case may be. The later confirmed RP will then move ahead and get and enlist the process and issue a Form G. Form G is basically invitation for expression of interest to submit resolution plans. So RP issues Form G saying to the prospective resolution applicants, saying that whoever wants to bail out this company or purchase this company can come forward and show their interest. And Form G will also specify certain criteria. For example, the COC will decide, say for example, Jet Airways, it's an airline company. So COC would want the resolution applicants who are showing interest to have some background of this airline industry. Or for example, the corporate debtor is into a specific pharmaceutical manufacturing. So the COC will want that the resolution applicant should have some expertise in pharma industry. Supposingly the company is a big size company, the COC would want that the resolution applicants would have certain net worth, certain minimum net worth, and small resolution applicants who are just who may not be able to implement the plan would not be part of the process. So eligibility criteria is defined before issuance of Form G, and that criteria is put in Form G. So every resolution applicant who meets those criteria, prospective resolution applicants, the PRAs, I will use this word for prospective resolution applicant. All the PRAs who are interested and would meet those criteria, they will submit their EOI, expression of interest, in response to the Form G to the RP. Once the EOI is submitted, the RP will process those EOIs. He will see whether that EOI is coupled, the EOI is proper in proper format, whether the resolution applicant meets the eligibility criteria, and whether EMD, which is required to be submitted along with the EOI, is submitted in proper prescribed manner. When all these conditions are satisfied, the RP will issue a provisional list of PRS. That provisional list of PRS will be shared to all the PRS as well as the COC members. If any person has any objections to that provisional list of PRS regarding inclusion or exclusion of certain PRA, he can raise his grievance before the RP at that point of time. After considering the grievance, the RP will issue a final list of PRS to all the prospective resolution applicants. Once the final list of PRAs are issued, the RP will then go ahead and issue an RFRP. Information RFRP is request for resolution plan. That's a document which defines as to what are the dues and what are the do's and don'ts, what are the conditions that the resolution applicant should follow while preparing and submitting a resolution plan. How is the process going to be conducted about evaluation of the resolution plans? That all of those terms are defined in the RFRP. The information memorandum, the RP will also circulate an information memorandum. Information memorandum is is a document about, this is a complete comprehensive document detailing the background, the working and all the everything related to the company, basically to the corporate data, financials, the contracts, the positives, the negatives, everything about the company. And evaluation metrics. Evaluation metrics are generally the parameters on basis of which the resolution plan will be scored or judged by the COC. So these three things the RP will circulate to the resolution applicants. Basis these three things, the resolution applicants will then formulate or prepare their resolution plans and will put their offers and submit it to the RP within the defined timelines. The RP will then check the resolution plans whether they are compliant with section 30 subsection 2. 30 subsection 2 lists down certain parameters that are required to be complied with, and if these plans are complied with those parameters, the RP will put those plans before the COC for their consideration. COC will simultaneously evaluate the resolution plan submitted by each of the resolution applicants. They will enter into negotiation. They can also enter into challenge mechanism or Swiss mechanism, whichever way they want. And then after final negotiations, the COC then puts the plan to the RP then puts the plan for voting, and the COC will then approve one of the plan or may reject the COC may then approve the plans, approve one of the plan or may reject all the plans as depending upon their commercial wisdom. So now having understood as to how CIRP is conducted, this brings us to a moot question as to in what circumstances is liquidation process initiated. So as you guys may have already guessed that once the CIRP is not fructified, or rather to say failed, only in that circumstances liquidation is initiated. So this are the provisions of CIRP. Under section 31, under section 31, if there is a plan, the plan is submitted to NCLT for approval, and in case if you see if the adjudicating authority is satisfied that the resolution plan is approved by committee of creditors and subsection 4 meets the requirements as referred under 30 subsection 2, it shall order then approve the resolution plan, and the resolution plan shall be binding upon all of the stakeholders. However, provided that adjudicating authority shall, before passing an order of approval of resolution plan, satisfy that the resolution plan has provisions of effective implementation. Where the adjudicating authority is satisfied the resolution plan does not conform with the requirement, it shall reject the resolution plan. Okay. So coming back to the question as to in what circumstances the liquidation would be initiated, the initiation of liquidation is detailed under section 33. This is the first provision of liquidation part. So where an adjudicating authority, so there are 4 circumstances. Let me list down. One is after expiry of 330 days or within the extended timeline, if there is no resolution plan, the NCLT can go ahead and approve a liquidation, initiate liquidation. Second circumstances, when the COC rejects all the resolution plans or one of the resolution plan, whichever case, there is no resolution plan on table, NCLT can go ahead and approve initiate liquidations. Third circumstance, in case if the COC during the CIRP process passes a specific resolution to initiate liquidation of the company, and when that resolution is put forth before the NCLT can initiate liquidation. And fourth situation where the liquidation can be initiated is when the resolution plan is approved by the COC and by the NCLT. However, during the implementation of resolution plan, the resolution plan fails or is not implemented. Then upon failure of implementation of the resolution plan, the NCLT can initiate liquidation. So all of these four circumstances are mentioned here. If you see, where the adjudicating authority, before the expiry of the insolvency resolution process or the maximum period permitted under for completion of the insolvency resolution process under section 12 or fast track CIRP under section 56 as the case may be, does not receive the resolution plan. So this is circumstances 1 that I told you. Second, rejects the resolution plan under section 31 of non-compliance or meeting the requirements as specified, and it shall pass an order requiring the cooperator to liquidate in the manner provided in the chapter. This is situation number 2. The situation number 3, where the resolution professional at any time during the CIRP process but before the confirmation of the resolution plan intimates with the adjudicating authority that decision of the committee of creditors approved not less than 66% of voting share to liquidate the cooperator, the adjudicating authority shall pass an on liquidation order. This is circumstances number 3. 4, where the resolution plan approved by the adjudicating authority under section 30 subsection 1 is contravened by the concerned corporate debtor, any persons other than the person whose interest is prejudicially affected by such contravention make an application to adjudicating authority for a liquidation order. On receipt of the application under section 3, the adjudicating authority determines that the corporate has contravened the provisions of the resolution plan, it shall pass an order of liquidation. So I have told you guys the 4 circumstances in which the liquidation is warranted. Now, one small thing that I missed while telling you the process of CIRP is that while the resolution professional conducts the corporate insolvency resolution process and determines and calls for the resolution plans, and the COC assesses the resolution plan, there is one important thing that the resolution professional has to do is that he has to get valuation of the company done, valuation of the assets of the company. So how is the valuation done? There are specific guidelines to which the resolution professional has to follow. That guidelines are enlisted in regulation 35 of the CIRP regulation. So before going to 35, let's see 27. So what resolution professional has to do? He has to appoint under regulation 27 registered valuers to value the assets of the company. So this registered, when I say registered valuers, it means valuers who have registered themselves with IBBI. These registered valuers have to be competent and be certified by IBBI to value those particular class of assets of the corporate debtor. Now, what is this class of assets of the corporate debtor? Generally and broadly, there are 3 classes of assets of the corporate debtor. One is plant and financial assets class. Second, plant and machinery class, and third is land and building class. So there is a possibility that one valuer may have a specialization in regards to valuation of a particular class, say financial creditor class, financial assets class. Another valuer may have a specialization to value only plant and machinery class. So he will have to register himself with the IBBI. That valuer have to be registered with the IBBI for that particular class. So if he's say the valuer number 1 is not registered, does not have the expertise to value plant and machinery, only has the expertise to value financial asset class, so he cannot be appointed for plant and machinery class. So ideally for each class, the RP has to appoint 2 valuers. For example, if there are many assets of the company belonging to all 3 classes, the RP has to appoint 6 registered values. Or if the RP wants to appoint two registered valuers, the two registered valuers should be registered with each of those classes of the each of those classes. So basically, two registered valuers having registration of that specific class. So the resolution professional shall within 7 days of his appointment, but not later than 75th day, 47th day of the insolvency commencement date, appoint two registered values to determine fair value and the liquidation value of the corporate debtor. The terminology is very important. What they have to, how do they have to value? They have to determine the fair value of the assets as well as the liquidation value of the assets. How do they determine? That is mentioned in the accounting standards, that the valuers have their own process of doing doing it. They know very well to do how to do it. For us, it's not really very relevant. The interim resolution professional or the resolution professional, as the case may be, may appoint professionals in addition to the registered valuer under sub-regulation 1 to assist him to discharge his duties in conduct of corporate insolvency resolution process. Is of the opinion the services of such professionals are required and such services are not available with the corporator. That means IPs can be appointed, lawyers can be appointed, and all of that. Who cannot be appointed as the registered valuers and the professionals are the related parties, auditors, and so and so. So under regulation 27 only speaks about appointments of valuers. What is important is regulation 35. So when I mentioned fair value and liquidation value, what is that exactly? So fair value and liquidation value shall be determined in the following manner. The two registered valuers were appointed under regulation 27, as I spoke earlier, shall submit to the resolution professional an estimate of the fair value and liquidation value computed in accordance with internationally accepted valuation standards after physical verification of the inventory and fixed assets of the corporate debtor, provided that the resolution professional shall facilitate meeting where the registered value shall explain the methodology being adopted by them to arrive the valuation to the members of the committee before computation of estimates. And in case if the estimates of two registered valuers in a asset class are significantly different, or on receipt of the proposal to appoint a third registered valuer from the committee of creditors, the resolution professional may appoint a third registered valuer also, and the value computed in the manner shall be in following methodology. So, in case if the both the valuers who have been appointed, if their estimates are quite considerably different, for example, a valuer says the value of the assets are 100 crores, and the other valuer says the value of the assets are 800 crores. There's a considerable difference. So, to bridge this difference or to have better understanding, the RP can also appoint a third valuer, or the committee of creditors, for reasons best known to them, they can also propose to appoint a third valuer. In that circumstances, third valuer will be appointed. And once the third valuer is appointed in this methodology, the fair value and the liquidation value will be computed. After receipt of the resolution plans in accordance with the code and this regulation, the resolution plans shall provide fair value and liquidation value and the valuation reports to every members of the committee of creditors in electronic form on receiving an undertaking from the member to effect that such member maintains the confidentiality of the fair value and the liquidation value, and the valuation report shall not use the information contained in the valuation reports to gain undue advantage or undue loss to itself or any other person. So now this clause is very important. What does this clause suggest? This clause suggests that these valuations which are arrived by the valuers are confidential in nature. These valuations are not to be disclosed to any parties except for the committee of creditors. Why are these valuations not to be disclosed? Because supposingly, if the value of the corporate debtor, all the three assets of the corporate debtor, the liquidation value comes down to say 100 crore rupees. And these values somehow are leaked, and the resolution applicants who are putting forth their resolution plans are given to understand about the liquidation value of the corporate debtor. They will easily sabotage the CIRP process, even if the assets are far more. The intellectual properties of the company, the businesses of the company, the value of the company is far more than 100 crores. These resolution applicants will only pay something more than 100 crores. That is, they may come and pay 120 crores, they may come and pay 130 crores. And if the company's assets are actually the intangible assets which the valuers do not consider while valuing the liquidation value, they do not consider this intangible and the contract value and the goodwill of the company. This resolution applicants will only offer something extra than the liquidation value and not the correct value of the company. And the committee of creditors will obviously compare the liquidation value and the value offered in the plan, and they will only get they will go forward and approve the plan. What will happen in this? The objective of IBC, that is the value maximization of assets, will completely be failed. Therefore, the resolution applicants are never given to understand what is the valuation of the liquidation value of the company. They are required to best estimate. They are required to assess that basis their best estimate, basis the information memorandum, basis the data available in public domain, and basis the physical records, physical due diligence that they can carry out. The valuation reports are never to be given to them. This is very important, and we are to understand this. So once the valuation is done, the committee of creditors and the RP gets to understand as to what is the fair value of the company and what is the liquidation value of the company. So when the resolution plans are received by the corporate debtor, the COC, while approving or rejecting the resolution plan, can obviously compare the values of the plan and the valuation reports, and they can be in a better position to decide whether to approve the plan or whether it's better to put the company into liquidation. So this valuations are very important to take to for the committee of creditors to exercise their commercial wisdom and take their decisions. Now coming back to the main topic as to how do we draft the liquidation application. So for sample purpose, uh, I have an liquidation application which is already drafted and the liquidation was already initiated in this respect of this company. You guys can check NCLT website and you can find liquidation approval order in respect of this company. This company's name is Swiss Ribbons. We represented the resolution professional of the Swiss Ribbons, and we continue to represent the liquidator of Swiss Ribbons currently. So the format in which the liquidation application is drafted is called as interlocutory application. What is the format of interlocutory application? I will surely show you, but the prescribed format is given in NCLT rules. You guys can check that check NCLT rules to get exact format. So interlocutory application, this is generally the outline, or I can say the skeleton of the application. Part Initially it will contain synopsis, followed with list of dates, then memo of parties, then the main application. The main application will then be coupled up with annexures. All of this combined will be divided into volumes. Each volume will not have more than 200 pages. After annexures, there will be an affidavit in support. After affidavit in support, there will be wakalatnama, then proof of fees that we have paid while filing the application, and the proof of service. So proof of service in that sense, this liquidation application is not required to be served to any parties. As I said, this is an application which is only to be filed to NCLT single-handedly by the RP, but other applications requires proof of service whether a response. So these are synopsis, followed up with list of dates and events, then memo of parties, and then the main application. So the main application generally have 5 parts. One is the particulars of the applicant, part 1. Part 2, particulars of the corporate debtor. Part 3, jurisdiction of the bench, as to how this bench has jurisdiction to deal with this application. Part 4 is limitation, and part 5 are the facts of cases. And one additional part in the end, that's relief center, that the prayers that we seek. So this is detailed application that we had drafted. I'll take you through entire contents of the application. This is the last part of reliefs. So if you see under reliefs, what reliefs are we praying in this application? To allow the instant application and pass an order of liquidation of the corporate debtor in terms of section 33 of the code. I've shown you what section 33 says, as decided by the COC in its 16th minute held on so and so. Prayer number 2, to appoint undersigned resolution professional Mr. George Samuel so and so registration number as liquidator of the corporate debtor in terms of section 34 of the code as recommended by the COC in its 17th meeting. Okay, and then crave leave to file any additional documents if required by the tribunal. So let us see what in detail as to what are the contents of the liquidation application that has to be forming part of the liquidation, and what NCLTs require, what the tribunals require while deciding a liquidation application. So liquidation application in general will have to be very detailed, elaborate, so as to explain the members, so as to explain the tribunal as to how did the RP from his appointment till the date the liquidation application was filed, what are the steps that the RP took to get the to resolve the company, and how was the CIRP process conducted, and why did the CIRP process did not fructify. So here, point para number one, the instant application is filed for seeking liquidation. Para number two, we will speak about the admission order. The in the beginning, as to in what circumstance, what date the admission order was passed. This is the date on which the company was put into CIRP. Second, then the RP invited claims of creditors in Form A. The annexures are annexed, whatever for whatever such amendments are made. Para number 4, after inviting claim, committee of creditors was constituted in accordance with Regulation 21 and Regulation 17. Certifying COC is annexed as Annexure 3. Who were the members of the COC? There were only 2 members of the COC. As I told you, there were only financial creditors. Axis Bank held 63%, roughly 63%, and Small Industries Development Bank of India, SIDB, held 36%. There were 2 members of COC. After the committee of creditors were formed, first COC meeting was conducted, where the progress of CIRP along with various agendas was elaborately discussed, and COC resolved to continue the applicant. Who is the applicant? The RP, the IRP, as the resolution professional of the corporate debtor. Then second COC meeting was held. In second COC, the applicant, that is the RP, informed the COC that to determine the fair value and liquidation value of the assets of the corporate debtor, in accordance with Regulation 35, I've showed you Regulation 35, he's appointed 6 registered valuers. Why 6? 2 in each class. And therefore, the valuers have done their valuation, excess of valuation exercise, and the average of their valuation boils down to what is the average fair value of the company? That was 17 crores 85 lakhs. And what was the average liquidation value of the company? That was 13 crores 26 lakhs. I'll show how is the average values computed. So let me, while I'm discussing this point itself, show how is the average value computed. So point number I hope the screen is visible to you guys. So if you see, there are 3 classes. First is class A, land and building. Second is second asset class, plant and machinery, inventory, stock. And third is the financial asset class. So for every class, there are 2 values appointed. See, Mr. Vimal Shah and Mr. Atul Shukla is appointed by for land and building. They are given values for land and building. Shed number 15, first land and building. Shed 26 units, second land and building. They have given their values. Okay. Then for plant and machinery, inventory, HS Mishra and DS Kajani is appointed. They have valued plant and machinery and inventory. For third asset class, financial asset, BR Patel and Jigar Shah is appointed. They have given their values here for all the financial assets. Financial assets, you will see what are the financial assets: debtors, loans, cash in and cash at bank, investments, and all of that. So now, how do you compute the liquidation value, fair value, and liquidation value? So Vimal Shah has given the fair value for this. Vimal Shah and Atul Shukla have given fair value here. This is the fair value, and liquidation value here. These 2 valuers have given fair value here, average fair value, and the liquidation value here. And then similarly, the B.R. Patel and Jigar Shah has given their fair values here. Average fair values, total fair values, and the average of both is this, and the average of the liquidation value is this. Now, we have got three fair values, 1, 2, this is 1, 2, 3, different for each class, and three liquidation values, 1, 2, and 3. Okay. So, all of these values, average value of land and building, average value of plant and machinery, and average value of financial creditor, average fair value of financial assets. All these three average values, all of these three values will be averaged, and the total average value will be total average fair value will be computed to 17 lakhs 85,000. 17 crores 85 lakhs. Similarly, this average fair liquidation value of land and building, average liquidation value of plant and machinery, average liquidation value of financial assets. All of these three average values, here are these three average values, will be further averaged, will be totaled, and the total will come to 13 crore 26 lakhs. This is the average total liquidation value. Okay. So this is the manner in which the fair value and liquidation values are derived. The averages of these values are derived. I will also take you deep into the valuation reports, just to make you understand as to how values are indicated by the valuers. So here, just a minute. So this is Annexure 7 collie. From here, 6 valuation reports are annexed. So what I showed earlier was the summary of valuation, and to justify each valuation report of each valuer is annexed here. Those are voluminous. I'll only go to the relevant page. So if you see, this is the valuation which was done by Vimal Shah in respect of what? In respect of the land and building. So in the initial page, in the summary column, he is indicated what is the valuation of first fair value of this is 65 lakhs as per him. Liquidation value as per liquidation value of this property as per him is 47 lakhs. Similarly, for the second property is given fair value and liquidation value, and total is come to so and so and so and so. These two values we have captured in our summary of valuation, which I showed earlier. Similarly, for plant and machinery, as you saw, we had appointed Mr. Himanshu Mishra, and he had valued plant and machinery. He is also given his summary. For plant and machinery, his fair value comes to 7 crore 81 lakhs, and for liquidation value comes to 6 crores 24 lakhs. So this is the manner in which they compute values. So I have showed you two reports. Similarly, there are all 6 reports which will give their respective valuation. Those respective valuations we will take into the summary, and we will prepare a summary of valuation and compute the average of all the values as I showed you earlier. Now let's go back to the application. We were at para 7. We were discussing the valuations. I have shown you how valuations are computed. So this valuations are very important to be annexed. Valuation reports and the summary of valuation is very important to be annexed to the liquidation application. This gives the bench, the tribunal, an holistic understanding as to what was the liquidation value and the fair value of the company. So the bench is able to understand as to, in case if there is any resolution plan which is received, what was the plan value and what was the liquidation value and what was the reason for COC to put the company into liquidation. Para number 8. In the same COC meeting, the RP discussed the eligibility criteria for inviting expression of interest. I told you that the RP has to decide the eligibility criteria for the PRS. And then after deciding eligibility criteria, Form G and Form G was published on IBBI website by the RP. Thereafterwards, in accordance with Section 20, then information memorandum was prepared by the RP and which was subsequently shared with the COC members. Information memorandum is also required to be annexed with the liquidation application. Then in the third COC meeting, evaluation metrics was discussed. Evaluation metrics are the parameters basis which those resolution plans will be judged by the or assessed by the COC. Then in this case, the RP received 2 expression of interest from 2 resolution applicants, namely one Omkara Asset and second was the promoters of the corporate debtor. Now, are the promoters of the corporate debtor eligible to submit resolution plan? Yes, they are eligible only if the corporate debtor is an MSME. If the corporate debtor is an MSME, the general rule is under Section 29A, the promoters of the corporate debtor are barred by submitting a resolution plan. However, the promoters can still eligible to submit a resolution plan if the company is registered under MSME. Section 240A gives that exemption for the promoters to submit resolution plan if the company is registered as MSME. So in this case, after the 2 resolution applicants came forward and submitted their expression of interest, the resolution professional issued RFRP and other relevant documents to both the resolution applicants. I told you what the RFRP means. RFRP means request for resolution plan. It contains all the terms and conditions as to how the process for evaluation of resolution plans will be conducted and what do's and don'ts the resolution applicants have to follow while preparing the resolution plan. Fourth meeting was conducted. The RP informed COC member that he had received letters and emails from both the resolution applicants and the promoters group and have sought extension of time to submit their resolution plans. So the COC then agreed to grant an extension of 25 days more to submit the resolution plan. Then fifth meeting of COC was convened when the RP informed COC that he had received both the resolution plans. However, upon scrutiny, the plans were found to be non-compliant vis-a-vis the criteria fixed by the COC and the provisions of the code. I had informed you too that the RP will only put the plans before the COC if they are compliant with Section 30 subsection 2 and the criteria that was fixed by COC. So therefore, accordingly the COC decided to provide further time to the resolution applicants to rectify the defects. So therefore, the resolution applicants were sent back and the plans were they were given an opportunity to rectify the defects. Again, there were some shortcomings in the plan. Thereafterwards, in the 7th COC meeting held on so-and-so, the applicant RP informed COC that he had received an email from Omkara Asset Reconstruction stating that they are in discussion with certain strategic partners who shall be introduced in the resolution plan for the sort of extension of 2 weeks. Further extension was granted. Here the CIRP period came to an end. Initial 180 days period came to an end, and therefore an extension of 90 days was sought by the RP. In the 8th meeting, measures were discussed in order to secure the assets. These are different deliberations. Okay. These are all issues that the RP was facing during the CIRP and the measures that he took in countering those issues and all incidental things. All of these details and elaborates, all the details have to be elaborately put into the liquidation application properly. Again, 9th COC meeting was held, wherein revised resolution plans were received from the promoters group and was discussed in detail. The RP informed the COC that Omkara Reconstruction Private Limited while their email leader communicated to the RP that they intend to stick to the resolution plan with no changes. Further, Omkara chooses to remain absent in the said meeting by physically or virtual means. Then COC meeting was held. The applicant states during the course of CIRP, applicant felt a need for forensic audit and external audit, and therefore a forensic auditor was appointed to conduct to understand what are the PUFE transactions. So, in case if there are any PUFE transactions which are identified by in respect of any of the applicants, that applicants become ineligible under Section 29A. But no, the PUFA applications are not only required to be identified, those orders in respect of that PUFA applications are required to be passed by NCLT. So this forensic audit is very relevant during CIRP. 11 COC meeting was conducted. RP provided a compliance report on the resolution plans and the fixed criteria and the criteria fixed by COC. Deliberations were undertaken. No final decision was taken on the resolution plan. Thereafter, suddenly COVID pandemic hit the nation and some time was passed. The applicant informed in the 12th meeting, the applicant informed that that he had received an email from the resolution applicant Omkara Reconstruction expressing their intention to withdraw from the resolution plan submitted in connection with the cooperator and sought refund of their AMD. Therefore, Omkara withdrew themselves from the COC, and thereafter only one resolution plan was before the COC that was submitted by the promoter group. Then there was some impact that the COVID had on the process, CIRP process, that is explained here. Then 14th COC meeting was held. Again provided the compliance report on the revised resolution plan. Deliberations were held. The COC said that the resolution applicant shall submit the resolution applicant, in that sense, not applicants, it is only one applicant. The resolution applicant shall submit resolution plan within 3 days and shall not be allowed any further modifications or rectification. Thereafter, 15th meeting was held. 15th meeting was held, and resolution applicants of the promoters were informed that the current plan shall be final and no changes shall be made. After discussions, it was decided that the said resolution plan dated shall be put for e-voting. However, surprisingly, a new resolution plan was the promoters wanted to make some changes in the resolution plan and they submitted a revised resolution plan. Again, a 16th CUC meeting was held, and then the compliance report of that revised resolution plan was presented by the RP. What was the difference in the resolution plan is stated here. And thereafter that resolution plan, it was decided that that revised resolution plan shall be finally put to e-voting, which would commence on 26th and end on so and so. So now if you see the resolution applicant, the promoter group was given ample opportunities to submit their resolution plan. The promoter group in with whatever best offer they could make, they had submitted the resolution plan, and the plan was put to vote in the e-voting, and an e-voting window was opened. I will show the e-voting, how is the e-voting conducted and the format how voting is done. Consequently, this is very important. E-voting was conducted on so and so to so and so date. COC with 100% voting share dissented. Dissented, that means they did not approve. For the approval of the resolution plan dated so and so, submitted by the promoters group of the cooperator, and accordingly approved for liquidation of the cooperator in terms of Section 33. Therefore, they dissented to approve the plan and they decided to put the company into liquidation. Why would this happen? This would only happen if the committee, if the committee of credit, if the COC thinks that the plan value is considerably less, and the company would be better off putting into liquidation, and they would fetch much more value in terms while the liquidation is being conducted. Thereafter, this was done in 16th meeting. Then 17th meeting was held, and in the 17th meeting, the COC with 100% voting share recommended in the name of the applicant RP, that is Mr. So and so, to act as continuous liquidator during the liquidation process. This resolution is also passed, and therefore the applicant, thereafter certain extension application was filed, and subsequently the reliefs. I've showed you the reliefs. First is to allow the liquidation. Second is to appoint the resolution professional as the liquidator, and third is to, in case if the tribunal requires, file any additional documents. Now let me take you to the relevant, these were the amendments that we had made. Yeah, but in the annexures, there are COC minutes. I'll only very swiftly show you the contents as to how minutes are prepared by the resolution professionals. So let me only take you directly to the relevant COC meeting minutes. So if you see, this is the minutes of meeting of committee of creditors held on so and so date. This is a meeting of 16th COC. This is 16th COC. If you recollect, 16th COC was the meeting where the liquidation was proposed. So these are various agendas that are put for discussion. So resolution 1 was, this was in regards to the CIRP cost. This is the CIRP cost that was put forth. And resolution 2. Resolution 2. This resolution was in respect of approval of the revised resolution plan. The resolution is made pursuant to the report dated so and so by the resolution professional to conduct committee of to the committee of creditors in accordance with provisions contained in subsection 3 of 30 of Insolvency Bankruptcy Code and regulations thereunder on the compliance of the resolution plan submitted by 4 signatories. It's a detailed resolution that is presented before the committee of creditors. And subsequently, what resolution is proposed? The committee of creditors hereby, subject to the approval through voting be carried out through e-voting process, resolution professional approves the resolution plan received by the resolution professional with total interest of so and so. The resolution applicant shall within 5 days of the approval of the resolution plan, after conclusion of e-voting, conveyed to the resolution, shall execute the performance guarantee, bank guarantee, and this is relevant. Resolved further that in case the resolution plan is not approved by the committee, requisite voting share of the committee of creditors, the committee shall be deemed to have approved liquidation in the deemed to have approved to liquidate the corporate debtor. Okay. So in this case, the requisite majority of committee of creditors was not formed, and the resolution the plan was disapproved, and the company was put into liquidation. Let me show you how that voting is conducted. So here are two agendas. If you see, first agenda is to ratify the CIRP cost. That is not relevant currently. Second agenda was to approve the resolution plan. So if you see, 100% of the committee of creditors have dissented, voted dissent, percentage of dissent, 100%. Total voting share, 100. So with 100% of both the committee of creditors have dissented against the approval of the resolution plan and propose to they propose to go ahead with the liquidation. So once liquidation is proposed, along with initiation of liquidation, there are some ancillary decisions that the committee of creditors have to take. Those are what? Those are there in the liquidation regulations. Those are 39B, 39BA, and 39C and 39D. These are 4 provisions which the COC, while deciding liquidation, has also required to take decisions in respect of this resolutions. 39B deals with meeting of liquidation cost. What is this? as to if the liquidation is proposed to be, the COC wishes to continue, put the company into liquidation. How does the COC decides to meet the estimated liquidation cost, and what are the plans that the COC will execute in estimating the liquidation to meeting the liquidation cost. That plan they have to set here. Second, assessment of compromise and arrangement. Whether the COC, while putting the company into liquidation, wants to explore compromise and arrangement as referred under Regulation 2B. Then, while approving the liquidation, whether the company wants to assess an opportunity to an option to sell the company as going concern during the liquidation. If yes, then the COC generally passes a resolution saying that after approval of liquidation, the liquidator shall make efforts to sell the company as going concern. Going concern in that sense, with not the company is not required to be dissolved. All the companies, along with its rights, title, interest, and everything, the company will be transferred to a particular buyer, and he will continue the company in its own name without dissolving the company. And four, what will be the fees of the liquidator in case of liquidation is approved. So these are some minuscule decisions that the COC is required to take while approving liquidation of the corporate data. So after evaluating all of this, after seeing the application and hearing the objections of the parties, if there are any objections made by some parties, the NCLT then proceeds and goes ahead to initiate liquidation of the corporate data. Once the liquidation of the corporate data is initiated, the name which is proposed by the COC or of the earlier RP or any other RP, if the NCLT requires, may be appointed as the liquidator of the company, and that liquidator is then entrusted with powers to continue and carry out the process of liquidation. What is done in liquidation? As you all know, in liquidation, the company is first tried to be sold as going concern. If the sale of going concern is not successful, then the company, the liquidator consolidates the assets, forms a liquidation estate, and then sells the asset. All the proceeds of those assets which are sold are distributed under Section 53. And once the distribution is done and the assets are sold, the company is dissolved and an application for dissolution of the corporator is filed before NCLT. Liquidation process will require a separate complete lecture to be if to be discussed. A separate lecture will have to be taken on a liquidation process. That's completely a different scope. So I hope everyone has understood as to how liquidation applications are drafted, what precautions are required to be taken while drafting a liquidation application, what tribunals generally require to see while the liquidation application is on board, what are the do's and don'ts. And I hope you have also understood fairly as to what decisions are, how are the liquidation decisions taken by COC, what factors are weighed, or the COC is influenced by what factors while putting the company into liquidation. I hope this seminar was fruitful and I could contribute my limited knowledge to you guys. And I wish you all guys all the best and very bright future and best of luck. Thank you.